Hey guys, Tony Denaro here. Welcome back to the channel. Oh boy, do we have a good one today. Is Adam Aaron and AMC breaking Delaware law with this proxy statement scheduled for March 14th, the vote on the conversion and the reverse split. Guys, I'm not an attorney. I'm just someone who can spend 5 minutes on Google and figure this shit out. So let's get right into it on today's episode of FUD Busters. Ladies and gentlemen, welcome back. I hope each and every one of you had a great day. As for myself, as I was browsing through Twitter this evening, I came across a bunch of posts from all the usual suspects talking about AMC in violation of Delaware law regarding the proxy vote that is coming up. And it's easier for me to take a minute or two and make this resource for you so that you can share it when this comes up. And I know it's going to come up on Twitter, on Space Calls, on all the YouTube channels that are against the vote. And so when I saw it, I was actually curious, do these guys have a point? Let's dig into it. It just took me a couple minutes to get the answer, and now I'm going to share that with you. Now, the main allegation, as you can read at the top of the screen here, is that APE and AMC solicitation materials contain false information and are in breach of the Delaware law. Oh boy, this sounds scandalous. I can't wait to figure out what they are talking about. The proxy solicitation materials instruct that AMC and APE will be voting together as one class. Ooh, that sounds bad. And I do know that one of them is a common stock class and the other is a preferred stock class. I wonder if AMC's army of attorneys thought about that in drafting these tens of dozens of pages in the creation of APE and the proxy statement. What do you guys think? Looking at the proxy vote in the voting section, it does indeed say that the common stock and the Series A preferred stock will be voting together as one class. Now, is that a violation of Delaware law? Let's go take a look. Delaware General Corporation Law, Subchapter 7 covers meetings, elections, voting, and notice. I wonder if this might say anything about different classes. If we go down to number 216 here, it's talking about the quorum requirements for stock corporations, where a separate vote by class or series is required. Where it's required already is setting up that it might not be required, but where it is required, a majority of the outstanding shares of such class shall constitute a quorum. Okay, Tony, so in which cases might a separate vote by class be required? That is covered in subchapter 8 under Amendment of Certificate of Incorporations, subsection 242B. Let me just scroll down here and I'll put a link to this document in the video description. In layman's terms, what the Delaware corporate law says is that if there is an adverse effect to the powers, preferences, or special rights of a class, only that class can vote on it. In other words, it would not be fair for the privileges or special rights of preferred stock to be changed by people in the common stock class. Only if you're in preferred stock class could you vote on something that specifically affects you. Now, I know that's not going to be good enough for some of you. I got you. Just spend one more minute with me. In the comparison that AMC published between the APE units and the common stock, they do cover voting rights. And you can see here it says that APE units and common stock will vote together unless Delaware law requires that they vote separately. See, the attorneys were already thinking about this 5-6 months ago. Same with the APE preferred units. It says the exact same thing. APE and common stock will vote together unless Delaware law requires that they vote separately. I know that's not enough. A couple more seconds. Just bear with me. Back in the end of July, filed with the Secretary of State of Delaware, the Certificate of Designations of the Series A Convertible Participating Preferred Stock, also known as APE. If we scroll down to the voting rights, it says that the APE units will be entitled to vote on all matters presented to holders of common stock, voting together with the holders of common stock as one class. Yep, this was already filed with the Secretary of State in Delaware back in July. Still not enough. I got you. So now we're going to go all the way back to finish this off to the 2013 original AMC Articles of Incorporation. Scroll down to page 159. Page 159, description of capital stock, voting rights, highlighted at the bottom. outstanding shares of common stock and preferred stock entitled to vote thereon will vote as one class with respect to all matters to be voted on by our stockholders. Yep, these crazy attorneys were thinking about this stuff all the way back in 2013. I think the case has been made. I'm not going to bore you with all of the other companies out there that I found the exact same wording, voting as one class. This is very standard. This is not a violation of Delaware law. I hope you found this useful. Please feel free to share it when you see this FUD come up. I am Tony Denaro, and I will see you in the next video. FUD Busters.